I wanted to do a really quick follow-up about this subpoena situation. Last night, I talked about how it's very unlikely that any kind of subpoena came from Blake. Now, I dealt with that very specifically because the process for subpoenas has a really good paper trail. First, you have to have some type of lawsuit in order to even request a subpoena. There's a lot of paperwork. The court has to grant you the right for this subpoena. You have to show why you need it, what you're looking for exactly. And if you'll think about what just went down about the phone subpoenas, these subpoenas are shared with opposing counsel, and they're shared for a reason, so that opposing counsel can make sure that what's being requested in the subpoena does not invade the person who's about to be served, does not invade their rights to privacy, that it's not overreaching, that it doesn't ask for sensitive and personal information. As we saw with the phone subpoenas, they did. And so what happened? Opposing counsel quickly filed a motion to quash. In the end, they had to be withdrawn because they just asked for too much. They'll probably be reapplied for. We may not ever see those because if they comply, there will be no reason for there to be a hearing or any motions filed against them. That may have already even taken place and we wouldn't even know about it. But they're not served without opposing counsel having a chance to make sure that they're not in overreach. What case did this happen in? Surely, if it was to get Jennifer Abel's phone access, she would be aware of this. We know that Stephanie did file a lawsuit against Jennifer Abel, Melissa Nathan, Justin Baldoni, Wayfarer Studios, and John Doe's 1 to 10. But this wasn't filed until December 24th. That means there's no way she could have used this lawsuit as a means to get those subpoenas and have supplied them to Blake on December 20th. Which we know was well before that because she claims those texts and emails came from a subpoena. It's not instant. There's a whole process that this goes through. So Blake would have had to have had the subpoenaed information well in advance of her filing. And we know that she was in talks with New York Times for possibly months. The as yet unverified dates showing it could have been even in October, which would have meant she needed those subpoenas long before Stephanie filed this lawsuit. So once the subpoenas are okayed by opposing counsel and do go forth, the paper trail, like I said, is very extensive. There's very particular instructions with them that has to be signed off on. None of this is instant. Once the subpoenas are served, there's a certain amount of time that the people have to get the information. It's not an instant process. So once that information is returned, it's brought back to the court, checked out by both sets of counsel, then it has to be admitted by the court. Then you can use that subpoenaed information, but you can only use it for the lawsuit that you requested it for. They are still considered confidential information. Their only purpose is supposed to be for that lawsuit. So, if I have a lawsuit and I send out a subpoena and I get that information back, I'm not free to go disperse this information. I don't get to carry it around and loan it to my friends if they need one. Hey, anybody need a subpoena? I'm especially not free to go stick it in the newspaper. This is still privileged information. If you look at the court filings, do we see what the subpoenas supply just filed for public to see? No, we don't. It's not there. We'll see if there's a dispute about them, if there are motions to quash them, but we have no idea what's in those subpoenas, what's returned from those subpoenas. It's not public information. It's information that's provided to counsel as discovery, and like all discovery, it is not publicly disclosed. If it's later used as evidence in the trial, we'll hear about it, but we will never see the contents of what subpoenas bring, just as they are. So, the reason I wanted to find out, did these subpoenas come from Blake? Because only subpoenas given to Blake through a lawsuit or through a complaint are allowed to be used by Blake. And even if they were used for her own lawsuit, that would not have made her free to take them and run them to a newspaper. Those kinds of files would be in her lawyer's files, not just given to her. Now on Stephanie's lawsuit against all the defendants I just read off a moment ago, she says on page 9.14 that Abel and Nathan's covert takedown and smear campaigns were revealed in black and white on Abel's company-issued phone following her termination, which Jones Works forensically preserved and examined in detail after receiving a subpoena for the phone's contents. Now, if Stephanie, through some other means, was able to somehow get this subpoena and get this information, she cannot share this with Blake. She could be found in contempt. So that's why I didn't even take into consideration any possible subpoena that was served by someone else for some other reason. Because even if that happened, it was not hers to share with Blake, and Blake had no right to share it with a newspaper. And when it comes to Stephanie's claims about a subpoena, that's also very suspect. For her to have been able to get such a broad subpoena to get all of the contents off of Jennifer Abel's phone without Jennifer Abel being to have counsel to try to quash it, to try to stop it, to try to limit it at the very least, that's very fishy. We saw when Blake's counsel tried to get just call logs and text logs and location information. This woman accessed Jennifer's cloud pictures, all of her messages. And we see that since she filed her lawsuit, she's gone on and tried to subpoena even more information of like WhatsApp and other chat companies to get even more information about Jennifer Abel. But how was she able to get absolute access to these documents and to get it so quickly? And we know she got it quickly because she was speaking to employees of her company and sharing that information. How do we know that? On page 140 of Justin's amended complaint, document 50, there's a screenshot of a message that's between Jennifer and an employee that still worked at Jones Works. Jennifer says, "I didn't mean to put you guys in a weird spot. Sorry about that. Just wanted to ask. Just know that whatever she's telling you guys about me or what I've done, it's not true. I've enjoyed working with you both and wish you nothing but the best." And what does this employee reply to her? "Unfortunately, your company phone says otherwise." What does that say? Stephanie has shared the contents of Jennifer Abel's phone with other employees in the company, making her claims that she had legally obtained this information through a subpoena very sketchy. What process, what means, and she was not supposed to share. This was protected information in case she needed it for a lawsuit. That's why all that matters is whether or not Blake actually had a subpoena for this information. That's why it's so important to prove that it wasn't possible for her to get it, because any access she had to someone else's subpoenaed information could land her in trouble. So yeah, subpoenas, it's not like you can say, "Oh hey, can I borrow your subpoena for my lawsuit?" Doesn't work like that.